Hi John, thanks for speaking to me.
Now we're talking about zero-hour contracts. What are they?
They're a particular type of arrangement where an employer contracts with a worker to do some work, but there are no specific hours in the contract. The contract is said to have 0 hours or unspecified hours, and they're a form of temporary work rather than an employment contract.
So what kind of legal status do these contracts have?
It's very vague. They're intended by employers not to create employment law status, so that rights such as a right not to be unfairly dismissed, or maternity rights, or for an employment to transfer on the sale of a business aren't created. But employers who do give regular hours can create an employment contract. It's a difficult issue where an employment tribunal can actually infer that a contract of employment exists because of the custom and practice and regular hours of work.
So basically, a zero-hour contract, there's no obligation on the employer, but there's also no obligation on the worker.
For there to be a true 0 hours contract, the employer can offer work, but the employee is not obliged to accept it. There's no what's known in employment law mutuality of obligation, so that it's purely a temporary basis, and it's for people who are perhaps students or carers who want regular flexible work, but they don't want to work the same hours every week.
Is there an opportunity then for a worker then to have more than one of these zero-hour contracts?
Some contracts provide for an exclusivity arrangement similar to what would be in many employment contracts, that you work for one employer and only work for that employer. The problem with 0 hours contracts is that if someone has no guarantee of a specific number of hours of work, but they're also prevented from working for another employer, that gives them issues about earning enough money, what's known as a living wage. And both the government and the Labour Party are very concerned about exclusivity in 0 hours contracts, and as part of a consultation which is ongoing at present, that may be made unlawful.
Now, is there an obligation for an employer to offer the minimum wage? And what about holiday pay and sick pay and things like that?
Any worker, there's a difference in employment law between a worker and an employee, but any worker is entitled to be paid the minimum wage. And for workers under 0 hours contracts, that also includes travelling to places of work if they're carers and they're travelling to their clients' homes, and also time when they're waiting on the company premises for their actual work with customers to begin. That has to be included in the number of hours for under the national minimum wage. All workers under the Working Time Directive are also entitled to holiday pay. That can be difficult for 0 hours workers because their hours of work will change every week, so employers need to be constantly calculating the number of hours worked and the amount of holidays that employees are entitled to. And particularly at the end of a period of employment, when workers are entitled to be paid for any untaken holiday, they need to carefully work out how much work has actually been done.
So then, why do employers like zero-hour contracts?
Because it gives flexibility. They're specifically designed in situations where there's an influx of work or another employee is off sick, so that they can have temporary staff where they don't form a formal contract of employment, and it gives them the opportunity to take on staff at the national minimum wage or a relatively lower level than they would need to pay to bring in agency workers who, because of recent changes in the law, have very similar rights to employees. So it's a useful, flexible way for employers to take on extra staff.
And why would an employee be interested in doing this?
Because they offer flexibility. Students and carers, they can work around their other responsibilities and just take hours of work as and when they want to.